So you think that your property contains wetlands and you want to know what you can and cannot do with your property? Hi, I'm Mark Stiles of Stiles Law down here at Studio B. So you own a piece of property, maybe it's your home, and you were told at one point in time that it contains wetlands. You've never confirmed any of this, but now you're wondering, can I build a pool deck, a shed? Move my septic system closer to those so-called wetlands. So what do? Well, the first step is to call your local conservation commissioner's office in your town hall. There's usually a wonderful person there answering the phone, willing to answer you, the taxpayer's question. Next, you tell them what you're thinking about doing, and you ask them what the requirements are. How far from wetlands? What are the buffer zones? What can I do and what can I not do? And what is the process? Typically, if you're within your right in the guidelines of the town and state, you will file what's called a notice of intent. Notice of intent to commence work, to begin work on whatever it is, building a pool deck, a shed, moving your septic system. That notice of intent is an application that will be filed with the Town Conservation Commission, and you will be required to attend a hearing. Now, typically people hire engineers at this point, but sometimes the work they're doing, they already have an engineer. That engineer will coordinate flagging the wetland lines and determining what those buffer zones are. They will coordinate having the wetlands flagged. So where is the wetland line? And measure out the distances from that. Certain towns utilize 25, 50, 75 feet, and 100 feet buffer zones. Once you file that application with your engineer or attorney, you attend a hearing and explain what you want to do. The board will then grant or deny your application. More often than not, they'll simply give you guidance and conditions on how to commence the work and how they want the work done. But I want to point out one fact that we see as closing attorneys all the time. People don't realize that that notice of intent is recorded. It's recorded with the Registry of Deeds, stating that the Conservation Commission has jurisdiction over certain work that's being done on that property. That needs to be released from the Registry of Deeds when the work is done. Many people think they had the approval when they went to that first meeting. This is not the case. Typically, a notice of intent will require that they go back to the commission with what's called an as-built plan. I did what I was conditioned to do and with the guidance you gave us in the notice of intent. Therefore, will you please issue us a certificate of compliance stating that we did what we were supposed to do. This very important step is often missed and sometimes delays closings. So it's very important that you, with your engineer and attorney team, know that once the work is complete, finish up with an as-built plan and then file an application for a certificate of compliance that you've complied with the conditions for building a pool, building a deck, building a shed, moving a septic system, or whatever it is you want to do on your land. Folks, I hope this was helpful. If it was, please share it with everyone and anyone, and I mean that. Go ahead, forward it. And remember to subscribe to our YouTube channel right here at Stiles Law. But always remember, when working with a financial, insurance, tax, real estate, or mortgage professional, and the topic of legal services comes up, please let them know that you want to work with the team at Stiles Law. Thank you and be well.